an adversary proceeding is a lawsuit. And in a lawsuit, each side is looking for some kind of result in the bankruptcy court that will be favorable to its claims. There's an old proverb that says, every man is right in his own eyes. Well, of course, doesn't mean that every man or every woman is right. It just means that each party believes it has the winning hand. So an adversary proceeding is a lawsuit to determine something, whether it's to determine whether a debt should or should not be discharged, or whether a plan is feasible, or, well, there are all sorts of adversary proceedings. So it starts with the plaintiff, and that could be the debtor, or it could be a creditor, filing a complaint in the bankruptcy court. And once the complaint is filed, then the defendant has a certain amount of time to file a response. And that response has to address the allegations that are in the complaint. And then there is shortly thereafter a status conference before the judge assigned to the case. Even prior to the status conference, each side is supposed to make disclosures to the other side to sort of streamline things and get things going. Then the judge will set a timetable. The big chunk is discovery, where each side gets to demand from the other side information, responses to questions, documentation, depose witnesses. Then after discovery takes place, and by the way, in the meantime, the parties are going to be filing things with the court per whatever the judge's instructions are. There may be a status report periodically. Eventually, there's going to be something called the pre-trial stipulation. And these can be really quite gargantuan. The last one I did was about 100 pages. In essence, what goes into the pretrial stipulation is a list of, well, these things we agree on. We don't have to litigate them. We don't have to go into court and try to prove that, yes, we're in the state of California, or this is whatever the year is. But these things we disagree on. So these are the things we want to focus our attention on at trial. And then eventually there's a trial, and each side will call its witnesses and make a presentation to the trier of fact. And then once the trial is over, then a verdict will be forthcoming. And generally speaking, in bankruptcy, we don't have jury trials. And that's based on a Supreme Court decision called Grand Financiera. Well, there's more to the name, but that's good enough for our purposes here. And what it says is, if a creditor has filed a proof of claim in the case, then by so doing, it has come under the jurisdiction of the bankruptcy court. And so adversary proceedings are typically judge trials, bench trials. There isn't a jury. Although once in a great while, there is a jury trial. Maybe one side demands a jury trial, and if it can show that in 1789, the relief it's looking for would have been available to it then it can get a jury trial. But then the question is, do you want to have the jury trial in the bankruptcy court and end up having to go to the district court because maybe that jury trial result isn't going to be the final word, or would it be better just to go to the district court and have the jury trial there? And in fact, I've got a case that is going to have a jury trial in the district court because we thought it was a waste of resources to do it in the bankruptcy court. And there is a mechanical process by which you get the case removed to the district court. You have what's called a motion to withdraw the reference. What on earth is that? Well, bankruptcy courts have their jurisdiction as derivative of United States district courts. And the cases, the bankruptcy cases are technically district court cases that are referred to the bankruptcy court. But the district court can, either on motion or on its own motion, withdraw that reference and have the case go back to the district court for hearing. So sometimes that happens, and that's what happened in this case we have pending. Then if either party doesn't like the result, that party can appeal. Well, if you started in the bankruptcy court, let's say you had a judge trial, you don't like the result, you can appeal to the district court, or you can appeal to the bankruptcy appellate panel. And once that's been done, well, the other party can say, no, I don't want to go to the bankruptcy appellate panel. I want to go to the district court. But once that's done, that's fixed in stone. By the way, the bankruptcy appellate panel is a panel of 3 bankruptcy judges who are not from your district. So if you think there's something arcane that requires detailed knowledge of bankruptcy law, and you think that militates in favor of your side, you might want to go to the BAP, the Bankruptcy Appellate Panel. If not, well, then go to the district court. Now, this is not to attack district court judges. They're very sharp people, but they don't have that specialized knowledge of bankruptcy that bankruptcy judges have. In any event, if you don't like the result at that level, then while I'm in the Ninth Circuit, you can appeal to the Ninth Circuit Court of Appeals. And in fact, I had a case very recently where we had the other side appeal a result to the Ninth Circuit, and I'm pleased to report we won. And then if you don't like the result at the Ninth Circuit, you can appeal to the United States Supreme Court. But the U.S. Supreme Court doesn't have to take cases it doesn't want to. It only takes about 75 to 80 cases per year from the entire country, and they're not all bankruptcy cases. There's a whole variety of cases that it takes. So generally, the Ninth Circuit is probably going to be your last stop. So there's a lot to an adversary proceeding, and sometimes these things settle because as the meter runs, because so much time is passing, the parties are spending a good deal of money on legal fees. And that tends to be a pretty strong incentive towards settling so that you don't have to go through this whole process. Now, when it comes to appeals, generally cases are not reversed, or holdings of lower courts are not reversed. I think the figure now is about 10% of appeals are successful. So you better have a really good argument why the lower court was mistaken in its holding in order to get any kind of a successful appeal happening. So there's a lot to adversary proceedings. In essence, though, they are lawsuits, and they are specific to bankruptcy. The term adversary proceeding does appear in the bankruptcy code and in the bankruptcy rules, but generally speaking, it is a term of art, and you won't find that, let's say, in the district court. You won't find that in the California Superior Court.